My PowerPoint is jamming a little, but it's coming on. Today's lesson is on paper 1. We shall be touching both paper 1 and paper 2. But today, let's start with paper 1. And our introductory topic is writing a will. I know it's on a side note that I've started with a will, but definitely we all somehow must die one time. All right, those whose microphones are on, please let's mute our microphones. Please let's mute our microphones. All right, thank you. I'm hoping the same members I had last time, and those who are new, my name is Teacher Onyo Isidoro, teacher of language and literature, and I'll be taking you through these lessons and also literature. So those who attend literature and English, it's a pleasure to have you here. So I want to begin from here to share your knowledge. What knowledge do you have on a will? What is a will? Let's begin by definition. What is a will? Yes, class. We can share, maybe one person or two can. Anzo, Gloria, can you say something? What is a will? I see a hand here, John. John, what is a will?
It's just a document I can use as I'm maybe preparing to share my belongings.
Let us retain the grammar aspect, the English bit of it, but you do score there that it is a document that one prepares on how his property should be shared. That is very true. What do you know about a will? Yes, John? Your hand is still up. Let us come in together. Simwe, you can say something. David. Yes. Which more information do you have about a will? Let's share. Keep the chat going. I'll keep reading. For those who are just coming in, our topic is on writing a will, and we started by definition. Someone was still defining. Yes, Technospark, you raised your hand. What is a will? Yes, you raised your hand. Say something. Technospark.
A will is a document prepared by a deceased. For example, if he had very many properties, and that document is written by the deceased on how to distribute his wealth.
Okay. Though the dead cannot write, maybe you would say before they died. Are we together? Thank you.
Yes.
All right, thank you. You can unmute. Good. So most of us at least have an idea that before we die, there is always a document on how you should share your property, and that document is called a will. So we most times in Africa we have issues. In Africa, most of us have oral wills. It is more common in the African societies. People think they have little to share, or someone may die even without writing a will, but they can be mentioning when they are alive, my property should be given to my first son. So, however, for us, we shall consider that it's a written will and it should be a formal document. So let me give you my definition here. We can always keep building on it. So by definition, I took it upon me to realize that a will is a formal or legal document that says or states who you want to take your property or wealth to be given to after you have died. So there are terms I want us to first consider here, legal or formal. When do we consider a document legal? When do we consider a document to be legal or formal? Yes, when do we consider a document to be legal or formal? Janet, but Janet can say something. Yes. Bagadira, Janet, can you say something? When do we consider a document? Yes, Susan, Tatiana. Susan, Tatiana, your hand is up.
A document said to be illegal when
Pardon? You're not clear. I can't. Your network. Yes, John.
Wakatika kana akantu.
Yes, John. When do we consider a document legal? Okay, let me give you my idea. Usually documents that are considered legal are documents that you have signed on, or they are documents that have issues, at least a witness or a lawyer has signed on it. So we usually say this document should be formal so that when you're not around, or legal, when you're not around, people do not fight to say maybe the document is fake. So it must be legal. That means it should be pronounced. That means it should be a document people can respect. So we go ahead and say that it states who you want to receive or to take your property when you die. Of course, all of us have to die someday. So I want you to know that before you die, of course, before you die, you must write a will. Now, it is also known that a will is only written by people who are 18 years and above most times, because that's when you think you're an adult. Before that, you are still under your parents. So I also want to find out from you, there are conditions, or I will let you know there are conditions that are necessary for a will to be considered legal. For example, the person writing the will should be of sound mind. You should not be forced by anyone to write a will. That will should be written by you willingly. That means it should be your own consent or your own move. People should not force you to write a will. Those are some of the things that we consider for a will to be valid. The other things we consider so much for a will to be valid is that there should be witnesses, people who saw you or writing this will and testify indeed that this will was written by you and not by force. The other one I've already mentioned, that no one should be forced to write a will. A will should be written by someone with consent. Okay, those are basics about a will. But the most important thing to know about a will is that it's a legal document that shows who you want to have or to take your property when you have died. You don't want a situation where people are fighting for things in your family. So before someone dies, they should always write a will. Okay, I have things. Of course, for us now in senior 3, I hope you know that in paper 1, we consider format, content, and then language. Does anyone remember those things? Is there anyone who can comment on that? Because the aspects in paper 1 section A, we usually follow what we call the format, the content, and the language. So as today, my interest is, as we learn, I'm here to teach you the format of writing a will, but also I should be able to hint on the content that is found in the will and which kind of language we use in a will. And straight away, I'm interested in letting you know certain things about the will. Hope it is an accepted document, sir. Can you please send me that? You're going to receive that WhatsApp link and you will join. I'm sure my admin is within watching those comments, so you can always add those comments. So I want us to begin with the common words that are used in a will, because sometimes you read these things and you don't understand. Of course, right now you might not be able to understand them all, but when you're writing a will, the common words that you use is maybe a last will and testament. That still means the will. So you can be reading a will and you find someone saying that I revoke, maybe I cancel my last will and testament. It still means that it's canceling the last will, because we believe that you should always update your will. Each time you get property, you should go back and update your will. So some people do it in such a way that they do it either yearly or every after maybe 5 months, depending on how fast your property is accumulating. Also, maybe one of your children can pass on, and if you had already given him property, you can still go and update your will. So you can cancel your previous will and then you write a new one. So that you will find that you can talk about the last will and the testament. It still means the word will. The other word we commonly use under the will is this word called tester. Those are terms, the common terms used, the legal terms. It can be a tester. It comes from the word testament. That is a person who writes and makes the will. This is now you, the owner of the will. On paper, that you're called a tester, the owner of the will. For example, if it's my will, I am the tester. If it is your will, you are the tester. However, if you're a woman, you are called a testatrix. These are just English terms, but also they are legal terms used when making a will. I just want you to know these words because once in a while you could be somewhere and someone tells you or reads out something and you're also aware. So the word is tester or testatrix for the female gender. The other word, the common word used is executor. A person who is supposed to carry out the wishes. When you want your will to be done, like they always say, may God's will be done. Now, when you want your will to be done, remember you have already passed on. So you choose someone, your brother, your sister, someone you trust. Please choose people who are trustworthy. Don't just choose anyone. Choose people who you know will not change the will to belong to them or to change the assets to belong to them. So that person who you give to deal with your will, to give out, distribute your property is called an executor. The person who is supposed to carry out the wishes. The female one is called executrix. That is for the female gender. The word is down there. You can be able to see the word is here for the female, and the male, you have this. I'm just getting you familiar with to the terms that we use. Please be writing these words. The other term is codicils. When you see someone talk about codicils, they are just additions or supplements. Sometimes when you're writing a will, you might forget something. So you can write that section of codicils, then you add other things that you could have forgotten to mention while distributing your property. It could also be how you want those things to appear, the appendices, who takes what, a summary of those. So it could either be supplements or additional words you're mentioning that you could have forgotten when writing a will. Those words are here. We call it the codicils. I will show you an example. Then the other one is the word revoke. Does anyone know the meaning of the word revoke? If you've met that word in the dictionary, it means to withdraw, to annul, or to cancel. So someone might say, I revoke my previous will. It means the person is canceling the will he had written a month before or a day before, and now he's choosing to write another one. So the word revoke is just a terminology. These are law terminologies. Revoke, it means to cancel, to withdraw, or to annul. The other common word you'll meet is bequeath. I bequeath my property to my first daughter. I bequeath my car to my last born. So bequeath is to hand down, to donate, to leave, to bestow, or to give. So the words are here. please write them down when you can, and then you also be able to memorize them so that when you're writing a will or when you're reading someone's will, you're not entirely lost. The other common word is bequest. Can I hear a yes if you're understanding these terms?
Yes.
Okay. Thank you. If you're understanding, then that is good. Let me continue because we need to learn these terms, but the most important is for us to know the format. These are just common terms. All right, let me check this out. Okay, thank you. I can see from the charts we're understanding. So when you continue with these terms, the other word is to bequest or bequests. Now this, at this point, it is a noun. Now it's a naming word here, not to bequest, but bequests. At this point, it is a noun, and those are gifts, legacies, donations, or inheritances. Your property, in short, they are called bequests in terms when we are dealing with a will. Instead of saying my gifts, you can say my bequests I give to this and that if you're generalizing. So these are common terms we use under writing a will. It is good for a learner, it's good for a person, even outside class, to learn how to apply these words so that we're able to speak the common language. Does that make sense?
Yes.
All right, thank you so much. So keep taking a few notes here and there, and then you can be able to share. All right. The other words, if we are to complete those words, these are the last words. We have what we call a solicitor. Who is a solicitor? A legal representative, such as a lawyer. Remember, I said for a document to be formal, there must be a signature, there must be people present, and among those people present, we want a lawyer, an attorney, or an advocate. These are the people who help to execute because the law permits them. Like the way a doctor has instructions to operate people, even the lawyers, they are supposed to come in terms of social aspects like this of handing over someone's will or executing someone's will. So a lawyer is important. That lawyer is called a solicitor. The other term is to execute or perform, implement. Those ones are common. Beneficiaries, definitely the individuals, organizations, charities that will benefit from your will. Now, it is not a must for your parent to die and leave things to you. Sometimes your parent can die and leave everything to the church, leave everything to the neighbor, leave everything to maybe other organizations like a school. So it is not a must for your parent to die and leave things to you. So the beneficiary of that will or who will benefit from those things is mentioned in the will. And when that has been signed on by your father, you must accept that your father has not given to you, but has given to another person. So that's what we are saying today, that those are the common terms we usually use when we are dealing with a will. Okay. So I know you take them down. I'm going to share these notes. They've already been shared in the e-classroom. You'll be able to pick them from there, and then you can be able to share. So those are the common terms we have. In case you have any other term, we can always put it in the chat, then others see. Okay, someone is saying their power has gone. Sorry about that, but you'll get back on with us. We are waiting for you. All right. Now, I want us to look at something now, which is very important. That is the format. In English language, a format is usually given 8 marks in paper 1. They try to give format 8 marks. But how do we get those 8 marks? That's what we want to see today. A format can also be called a layout. How does how are you able to identify that this is a will? You know, so definitely there are aspects, or we can call them aspects or elements of a will. We want to look at some of them. The first one is a title. A will must contain a title. That title, for example, you can have last will and testament of, then you mention the person. Or you can simply say, you can mention the name Kavanda's last will and testament. So that is what we call a title. So for every will, the writer of that will must have a title for it, so that we know that this will belongs to so and so. It is very important. So you can have a title like last will and testament of Kavanda James, or Kavanda James's last will and testament. That can be a title. The second thing on a will, when now after writing the title, you go to your first paragraph. And in English, we write what we call indented paragraphs. You indent, you leave space from the margin. For every paragraph that you start, you leave space from the margin. That is called indented paragraph. So we expect a learner or anyone who is writing a will to begin his first paragraph by telling us who he is. In that first paragraph, you need to tell us who you are, where are you from, where are you currently, and also your age. For example, you can say, then you put your name, Kavanda James, presently. Now that is your current location. Presently, maybe located in Masaka, maybe Masaka district. Then you can mention other things. For example, tell us that Kavanda James, presently at Masaka district. Then you tell us which part of Masaka you are, maybe Chitovu zone, this and that. Hereby, then you continue. So, however, you should tell us who you are, where are you. Other features you can add there is the name, maybe the age. Aged, maybe Kavanda James, aged this and that, currently in such and such a place, but a resident of such and such a district. You tell us who you are. So those are the details we want: your name in the first paragraph, your current location, your age. Other things can come in, other people mention other things, but those are basics you can have in your first paragraph. You must mention in that first paragraph that you revoke the last statement or the last will. What did we say the word revoking means? Anzo, Gloria, what is to revoke? Anzo, Gloria, what is to revoke?
Withdraw.
Oh, withdraw. Though you're not Anzo, that is, please Galaxy F51, can you rename yourself?
Abdi.
I beg your pardon?
Abdi.
You're called Abby.
Abdi.
Okay, you can do that. Thank you. Oparok, Paul. What is to revoke?
Withdraw or cancel.
Yes. So you must mention it, because each time you're writing a new will, you don't want the wills to conflict. So you must always pronounce that you've canceled the previous will.
So to withdraw.
Yes, it is to withdraw, it is to cancel, but you must cancel all those other wills that you have written before. Each time you write a new one, you must always cancel the old one, so that this is the only will that will be executed on your burial or after your burial. We don't want to have confused mourners or confused family after. So let us endeavor always to write that. It's one of the statements we add in our first paragraph, that I am canceling or revoking my last will. That can be just your first paragraph. It is good enough. Now, some people write them with subtitles. For example, after that first paragraph, the next thing you can put a subtitle, marital status. Others write it just in a paragraph. Instead of mentioning, instead of putting a subtitle, marital status, they simply say, I am married to one wife. If you're married to 3 wives, please mention, even if your first wife does not know the second wife, mention her also here, so that in case you're to give her property, she can also claim for that property. So in your second paragraph, we expect you to mention your marital status. You can put it in a subtitle or just a paragraph. Remember, we use indented paragraphs. So you tell us that I am married to one wife, maybe Joanne, whatever wife you have at that point. If there are two women, mention them. If there are three, even if they are concubines, please mention them here so that they can get property. These days, the law allows. I am married to one wife. That is for me who is faithful. I have one wife, I say. I am married to one wife, Joanne. Joanne, and definitely if you're wedded, she could be Joanne Kabanda, because initially that is the name I'm using. Joanne Kabanda. Ali's mother, please mute yourself. Okay. Married to one wife. And then also, you can go on and describe a little bit of here and that. So you mention your marital status and the number of children later on. You go to the next paragraph. You mention the number of children you have. You can also talk about their age here. Mention the age, the sex, be able to mention those under your children. Please don't leave people doubting which child is that. Mention the sex, mention the age, mention all necessary information that is attached to that child. For example, I have 3 living children. Are we together? I have 3 living children, mentioned 2 girls and 1 son. Then you mention the names of the girls and also mention maybe the work they do, if they're already working. If they're just young girls in primary, also mention their level of education. That additional information makes it easy for property to be shared. Are we together, class, up to this point? Can I hear some replies?
Yes.
We are clear.
Yes,
Thank
sir.
Thank you.
Yeah.
Thank you. All right. You can
Yes.
keep commenting. Maybe you've not had something you can say, and then I will be able to. I'm also looking at your chat at the same time. All right. Thank you. So you go ahead after your children, give us enough details so that we do not doubt who these children are. The next thing we want to see is your property. Some people can choose to mention their property and then later on they give it out. Others mention the property while giving out. Those can be the same. For example, you can have a subtitle and tell us that property left behind as part of my estate. Then you mention maybe 12 heads of cattle. Also tell us where that farm is. Tell us where that farm is. Are we together? Tell us, thank you. Tell us where the only motorcycle you have is, or who is riding it in case it is a Bajaj. In case it is maybe a house, tell us my house, mention the type of house. Is it a bungalow? Is it a flat? Are they rentals? Mention exactly where they are located. So that is also very important. It is very important for you to mention to us who is maybe currently managing them so that there is no struggle. Now, also under children, sometimes you have children who are not yours. You can also mention them. Please do not shy off. Mention those children. If you intend to give them some property, you can mention who they are. So please, it is important for you to mention your property, but also describe that property very, very well. Otherwise, you might cause commotion. Then sometimes you find that you are sharing property with other people. For example, it's a partnership. Maybe you're partnering with a company, or you're partnering with your brother or any other person. Please mention that so that you reduce commotion. Some people die and they leave more commotion than they were alive. We want to eliminate that by making sure that each property is mentioned and talked about with equal magnitude. It is very, very important. Okay, so I mentioned here that describe and distribute property. After mentioning your property, now you can come and describe and mention it. I said you can do it once, or you can be organized by saying, this is my property. Then you go ahead and describe those houses. For example, here in my outline, I mentioned 12 heads of cattle. Tell us where the farm is, maybe at home here. Then you say 2 houses, 1, or even if you left it like this, then in the next paragraph, now you describe them. The cows, how many heifers, maybe, you know, how many bulls, how many cows, how many calves, if any, you mention them, and then you distribute. For example, you can say the banana plantation in Chankwazi should be given to Muhammad, my firstborn. That is what we call describing. Maybe you can say the banana plantation, which is 4.3 acres, or which is 2 acres, or which is 1 acre, should be given or shared between my children, depending on how you want it to be shared. Mention the property, describe the size of the land that plantation is seated on. It is very important for you to mention the size. It is much simpler for the executor to do it for you. And you make sure all of that is done in that paragraph. You can do it in different, in different paragraphs. Or you mention, for example, each property. For example, you can choose to say, maybe if it's land, you can choose to describe land in its paragraph. Then you choose, you say cows in their paragraph, the houses you have in their paragraph. But if you have very little property, you can just put all of it in one paragraph. There is no problem. However, we just don't want very bulky paragraphs for us to be organized. Someone is saying, sir, what if the children are more compared to the property? There is no way. You only distribute what you have. If you have more children, they should share the 1 bicycle you have. If you have 3 children, because sometimes you have a lot of property and few children, they still share. Even the many children can share the little property. It is allowed. It depends on you as a father. Do you want your children all to receive? Some children maybe are not worth receiving property, you know, depending on your conduct. So we can always say that. Roland, your hand is up. Can I hear you? Roland, your hand is up. Can I hear you?
What if one of the children, more of the children are astray, and then you have only one who is on the track? Is it eligible that you should give that one, or even the 3 should be?
Now, distribution of property is a personal move. For us, what we teach you is how to divide your property. However, you also don't want to give the most indisciplined children more property. I can guide you by saying, maybe let the most disciplined run the estate and the rest can be beneficiaries. You can simply give them something. However, as a lawyer or as a teacher, I cannot tell you, let all children receive equally, but you distribute according to how your children, how you feel and how much you have. That's how you can distribute. However, sometimes you might distribute only to one and they kill that one. So make sure you also strike a balance. Don't be too generous, or don't be too strict, but also don't be too, don't give a lot of freedom for children to do what they want after you have gone. Nansubuga Agatha.
Pardon, sir.
Agote, you want me to pardon the explanation of the question Roland asked? Yes? Agote?
I did not hear the question.
Whose question? For Roland?
Yeah.
Roland asked, what would happen if you have children who are indisciplined and only one child is disciplined? Do they get equal property?
No.
And for you would not give them equal property, isn't it?
Yes.
Yes, so that's why I'm saying that distributing property depends on you the parent or the owner of the property. Are we together? So that one has, you cannot be so strict. It might not disturb you a lot. Just make sure everyone gets something. Someone is saying, okay, David, can you be able to tell us exactly what you have not understood? Then I can be able to help. David, are you here? David S., I've received your message. You can be able to ask the exact question. Yes. Your network, please try to be more clear.
I'm not getting you very well.
On which point?
I'm not getting you very well.
On which point? Yes, on which point?
When explaining about the property left behind.
About the property left behind?
I was off.
Okay, now it's very... Okay, it's now very hard for me to go back since you've just joined. But what we're saying is what we are now doing is looking at the format of a will. And we agreed that we start with the title. After the title, you have various paragraphs. We have agreed that the first paragraph must always contain details. For example, the name of the... Please do listen. The will must always contain in the first paragraph the name of the person, the current location. You can even tell us perhaps which kind of job you do. All those things are welcome. There is no problem. And then after that, we encouraged you so much to continue and tell us additional information in terms of, are you married? That is, you can talk about that in the second paragraph. After telling us that, you tell us if you have children and how many, and then tell us the property you have. After telling us that property, describe and distribute that property according to the number of children you have. Those are also there. Then the second, you continue in the next paragraph. Acknowledge. This is a very, very important statement. After you have distributed your property. Now, remember I talked about the special bequest. Do you remember this? The gifts, legacies, or donations. In case you don't have anything to donate to any organization, in case you don't have any gifts to donate, then you will not have the next session called the bequest. Then you do not have to write the paragraph of bequests. However, if you have property to donate, let's say to an organization, after describing your property and distributing it, the remaining property, you can choose to donate it. That paragraph, we shall call it, you can talk about the bequests. You can call it the special bequests. As a paragraph on its own, you can write a subheading and say special bequests. Those are gifts. Then you say, I give maybe my last cow to my neighbor who was very helpful to me. Then you can also distribute, if you have many bicycles, the last bicycle I give to maybe my church. So you can write those special bequests under those donations under the paragraph of special bequests. Now, in case you forgot to include people, you also have another chance. You can write a paragraph of individuals omitted from bequests. You can also write them. If you've forgotten to put them in the property and in the gifts, you can also talk about individuals omitted. Are we together?
Yes, madam.
Okay. And then you can also mention, maybe there are those people you intentionally don't want to give your property and you know they will cause headache. You can also include them among the individuals omitted. Are we together? You can clearly tell us that my elder son, Joram, maybe you can say, if, for example, you say, the failure to do so is intentional. You can say, my son, Joram, I leave nothing to you. You might give a reason or may not give a reason, but you clearly tell us that your intention, or rather, the reason I did not leave anything to Joram, and it is intentional. You acknowledge that it is intentional. You did not forget, so that he does not wait or disturb anyone that he wants property. Are we together? You can mention clearly people you don't want to benefit from your property or to benefit from anything you have. You can mention it in a paragraph. And then after that, you now go ahead and tell us, you're able to tell us the executor who is going to do this. Are we together? Tell us who is going to execute your will. Of course, others, you might find other wills are detailed, other wills are not detailed, but it is all because of the property and the challenges of different families. I was still talking about this paragraph, that you must acknowledge that you have written the will in sound mind, willingly, without anyone forcing you. You also can mention who was present when you are mentioning, when you are making that will and signing it. Mention the lawyer. Please, Paul, stop writing on our class list. Just tell us the lawyer. You can mention the name of the lawyer who was present. For example, you can say, in the presence of these witnesses, then mention the name of the person and the lawyer. It is very, very important. And then also mention that my will be executed by, then you mention his what? His name. Those are very, very important. Are we together? Are we together?
Yes, sir.
Yes, yes.
Okay. So it is very important for us to do that. Mention who should distribute your property after in the presence, of course, of other people like the lawyer. And then lastly, you must tell us the witnesses. Usually, I'm going to give us, let's look at this last bit. So you here, signed by, you put here your name, your signature is here. You are the tester. You remember this term, the tester. The tester is the writer or the owner of the will. You must be able to tell us, and then give us the witnesses who were present. Tell us the name of the witness, they sign. 2 or 3, even if you mention those, it is good enough. Are we together?
Yes.
Okay.
We are together.
Yes, then the last statement you can mention, you can still acknowledge that all these signed in the presence of the lawyer. As the witnessing advocate, those are all important. So that is just a rough sketch of what it is. I have an example that I will share both in the WhatsApp group and the Google Classroom. I'm going to share and we shall be able to find those things there. Let me look at your chat and I start welcoming questions. Do we skip lines when writing a will? No, we do not skip lines. In English language and literature, that will be double paragraphing. We use what we call indented paragraphs. That is leaving some space from the margin. Are we together? Is it in capital letters? No, definitely. You cannot write the entire essay in capital letters. Like any other grammar rules, if you're writing subtitles, the initial letters will start with the capital letter. The initial letter, not the initial word. The initial letter. For example, if you're writing executor, the E will be in capital letter if that is if you're writing it as a subtitle. I donate the property to another person's child. Since it's a donation, after you've distributed, all your children have gotten property. The excess, if you have a lot, you can donate. You can donate to church, you can donate to any other person. It is okay. Someone is saying, if your children are badly behaved, can you give them? Now, it is one thing to be badly behaved, and it's the other thing for you as a parent to punish. You cannot punish your child for eternity. You can leave some property to your child despite their behavior, unless otherwise. I cannot dictate if you should give or not give. However, me, I'm teaching you that if you're to give, this is how you do it. You must mention who takes what. If they are to share, make sure you mention that the two are sharing, and also mention if it is 50-50, mention it. If it is 20-80, mention it. Don't just say share. Mention the quantity the two should, the each will get while there. I told you I have an example. I do not want us to crowd here. It is in our notes. I'm going to be able to share it. Let me see here. But I'll literally want us to have it in our English language. Right, it is in my phone. Yes, notes. So I would expect something like that to happen. So, keep your questions coming. This is literature. Keep your questions coming. I have a different file for those. Can I have now you ask questions? What do I not use? What if I do not use? Now, you cannot ask me what if you do not want. It is like telling me, what if I don't want to pass? I can say it is okay if you want to fail. However, it is what we call a grammar rule. In English, like the way you say in history, history has its rules. Biology has, you can never tell a chemistry teacher, what if I don't want to heat it? If the instruction is heat it under this temperature, that is what you do. So it is an instruction, and it is a grammar rule that indented paragraphing is important. So it is not by choice, but it's a rule of grammar. Like the way you say a full stop is a must. What if your children, okay, now can I have people ask oral questions? I'm open to discussion now. No, is that John?
Teacher.
Yes.
Do I need to put a date on the will? Yeah.
On your will?
Yeah.
Depending, like for example, sometimes people mention it when they are currently writing in the first statement. Are we together? Yeah. Someone can mention it, or they can mention when they are signing. If you look at the place where they sign, other people can sign and put a date when they're signing that will.
Okay.
Yes, those two areas can accommodate that.
They're going to stand.
Susan? Susan, your hand is up. Kevin? Maureen, Kevin, can you please mute yourself? You're not within class. Waswa Walugembe, can you ask a question? Your hand is up. Yes.
Excuse me, madam. Yes. What if I don't have children?
What if you don't have, but definitely you must, maybe you have a wife or you have relatives. It's okay for you to give it. We have, under the part of children, we say, if any, if you have children, that's when you give them. You cannot give someone who is not around. You only give property to people who are around. Is that okay? So for children, we usually say children, if any. Here, even the word is here, children left behind, if any. Yes, next question, Sheila, Rebecca. Yes.
Subheadings allowed.
Yes, you can have them in subheadings. You can decide to write them in just paragraphs. It is okay. Mwanguzi is oh, Wasuwa Walugembe. Roland, can I hear from you?
Is it okay if you use block paragraphing?
Block, no. In English language usually rarely uses that or never uses that actually. Blocking, we do not block. We use indented in English and literature. We prefer indenting. Roland?
Okay, thanks.
All right, you're welcome.
Okay.
Nansubuga. Agatha. Nansubuga, Agatha. Agatha. Yes? Roland, mute your microphone. Davis, S, can you ask a question? Your hand is up.
Yeah, I was asking, can I?
The last page.
I
The last page.
You want to see the last page?
Yes.
Okay, I'm going to do that. The next question. Next question. Someone was mentioning something before I got a Jen.
Do we write the title with capital letters or small letters?
You can write that one in capital letters, it's okay.
Okay,
you can
sir.
write it. Yes. I got a. Janet, can you mute your microphone if you're not asking a question? Okay, thank you. Paul, you have a question? I'm waiting.
Now, teacher.
Excuse me, teacher.
Yes.
I'd like to ask here.
Please do.
Is that when I'm to write, can I put the date in the will or I'm put it aside after the will?
How do you put it away? It is part of, if you want, like, do you see here on the last page? Are you seeing where my cursor is, where I'm pointing?
Yes.
Between the name and the tester, you can also put here date. You can put the date in the middle there. It's very fine. Because this is the date that it will indicate that this is when you wrote it. I also said you can maybe squeeze it. You can put that date as part of your first paragraph here. You can add it here. However, I have no problem it appearing here in the middle here. It is very fine.
Okay, thank you.
You're welcome. Taking questions. There is a hand up. Anyone can ask among Davis?
Yeah, teacher.
Yes.
I was asking.
Yes.
You say that we have to include the people, like the witnesses. Can I only write one?
No, please at least put two. And usually it's preferable male, female. You see, when you're two, we can say you connived, but at least when you're one, you can say, when it's only one person, you can say maybe you connived with the other one. But when there are two people, at least that is good testimony enough.
Okay.
You're welcome. James Williams, your hand is up.
Oh, teacher, I just wanted to request you to allow me see the first page.
Okay, you want to see the first page? Okay, that is done.
Yeah.
While the other people are asking other questions, I'm open before time. We have only 2 minutes.
Sir.
No.
Sir.
Yes.
Excuse me, teacher.
You're excused.
Who is a testator? Excuse
That is
me,
you.
sir. Who is a testator?
The tester is you. The testator is you, the owner of the document. That is a term we use. The owner of the document is called a testator here, rather the tester. Comes from the
Excuse
word
me, teacher.
testament. Yes.
Now, shouldn't the will contain the date?
But we have talked about the date. We have said you can add it. You
How
can
about
put.
revoking?
Can I answer one person at a time? We have
What does
agreed. Please let me answer the one person at a time. We have all talked about placing the date. You can put it in this place here. You can put the date here.
Excuse me, teacher.
I'm going to answer you just a minute. Let me answer this person of where to put the date. You can put the date around here. When you're signing off, are we together?
Yes.
Yes, where that testator puts his, after signing, you put a date. You can put here, it's part of a signature. You can put them together. The person who was asking to revoke is to cancel, to annul. When you say, I revoke my last testament, you're denouncing it. You're making it invalid so that we do not withdraw, yes. So that we do not refer to it anymore.
Okay, thank you.
You're welcome. Someone is saying, thank you, sir. I've got, okay, that's not a question. All right, that is okay. You are excused. Your network is poor.
Okay.
You're saying?
Excuse me, teacher.
So, teacher, time is up. We need to conclude.
Okay. No, we're just now on last bit of questions. Let's continue chatting in the WhatsApp group. The link has been sent.
The number.
Okay, thank you so much.
Thank you for your service, teacher.
Thank you. Welcome there.
Thank you,
Teacher,
teacher.
thank you for your service.
God bless all of you.
Thank you.
Sir, I wanted to ask about
Nice
the WhatsApp
time, teacher.
group.
Okay, teacher, have a